this was the first opinion of the court in this dispute here in these proceedings. And a second one followed on the 22nd of January, some weeks later, where the court touched upon two other questions. The first one is a question which goes back to a motion that Samsung had filed in the proceedings. And the question is, can the implementer request also damages which would cover all losses, including litigation costs? So if we are in a situation where you have a potential breach of front duties by the patent owner, can the implementer, is he entitled to damages which would cover also litigation costs, or is this not the case? So this was the first question. And the second question that the court addressed here was whether there are conditions or there are circumstances under which the SEP owner might set aside its duties arising out of the front commitment and, for example, start litigation or start court proceedings. Are there circumstances, are there conditions under which this could be applicable and allowed if we're looking at the IPR policy? So these were the two questions the court addressed here. The first one was answered by the court in the affirmative. So the court said yes, the implementer is entitled to damages that cover all losses, including litigation cost. But, and this was a small footnote by the court here saying this does not apply only with respect to the implementer. This equally applies to SEP owners, meaning that the court thought the question or the motion of Samsung was one-sided because it considered only potential bad faith behavior on the side of the patent owner, whereas the court said actually bad faith behavior could be also on the implementer side. So yes, you can claim very comprehensive damages, which would include also litigation costs, but this is not only for the implementer, this is also for the SEP owner when the conditions are met. Which conditions are applicable here? Again, the court looked at French law. We said already before, it's about the IPR policy here. So French law is the one, the legal standard that should be used here. The court looked at first the nature of the front undertaking and how is it to be qualified under French law. It's found here that the front undertaking, according to the IPR policy, is to be treated as a stipulation pour l'autrui. Under French law, this is more or less a contract for the benefit of a third party, which put simple means that you have the patent owner and the SDO, which in our case is ETSI, signing a contract by which a third party, in our case an implementer, for example Samsung, could extract rights and could extract claims. So this is how the stipulation pour l'autrui works under French law. The fact that the ETSI front undertaking is qualified as a stipulation pour l'autrui is now pretty common. One could say the courts in the UK, for example, but also in Germany and in other jurisdictions have accepted that qualification, and this is more or less a common ground today. So after having said that, the question is, how does this work, and what type of obligations does this contract create? And here the court clarified that the stipulation pour l'autrui, the front undertaking, it creates reciprocal obligations, especially also a duty of good faith, of negotiating good faith, meaning that it creates obligations for both the SEP owner, who actually makes the contract, signs the contract, and the implementer, who wishes to refer to the contract and extract claims or positions from the contract. So here, a very clear statement of the court, this duty of good faith that arises from this contractual agreement is reciprocal. It's a two-way street. It's not only on the patent owner side. This means, of course, on the other hand, that breach of the duties can occur on both sides. So both the patent owner can breach its duties, also the implementer can breach its duties. And if this is happening, if there is a breach, then damages are brought in the eyes of the court, no matter who breaches the duty. So there is no differentiation if a party is not acting in good faith, irrespective of whether it's the SEP owner or it's the implementer, then the breach of the duties creates a duty to pay damages, and this was a very clear statement of the court here as well. Having said that, the question remained open: what do these damages actually cover? And here again, the court applied a French law, which basically stipulates that litigation costs are recoverable as damages. So in principle, under French law, and this is not something that applies only in the SEP context, this is seems to be a broader rule, a civil law rule, that damages are pretty broad and litigation costs are part of the damages. So they can be recovered in court by either party, of course, if the counterpart has failed to meet its front obligations. So this was the first question. Then the second question was, is it possible for the SEP owner to unilaterally discharge their front obligations? Are there scenarios, are there conditions under which this should be possible? And the answer of the court here was yes, there can be a temporary suspension. But again, the court noted here that this applies for both sides. It's not only applies for the SEP owner, but it also applies for the implementer. So a temporary suspension is possible for both sides if the other party acts in bad faith. Again, here the question was to be decided under French law. This is what the court did. And then the court started reflecting of what actually the front obligation means and what its impact is, what its effects are. Here, just for us to keep in mind, the ETSI front undertaking is an irrevocable undertaking, meaning that if it is given, then it cannot be taken back, to put it very simple. So here the question was, is this something that also means that the obligations under the front undertaking are irrevocable in the sense that they cannot be suspended? Or should we differentiate between the irrevocable character of the front obligations of the front undertaking and the fact that the duties that arise out of it could be treated differently if circumstances allow or require that? So the court looked at the front obligation and said, of course, this is something that contractually burdens the patent to be licensed on front terms. This is something that is attached to the patent after it is made. The front commitment is attached to the patent. It follows the patent. And is, of course, irrevocable in the sense that it continues running with a patent after it is made. So there is no stop there. For example, if you have a transfer, etc., the front obligation, the front undertaking continues to be there. Now the question is, does this mean that the obligations that arise out of it cannot be suspended at any time? The court said no, however. You should distinguish these things. It's two different things, especially the obligation to negotiate in good faith, which arises out of the front undertaking, may be temporarily suspended in the eyes of the court. The court said here you have to look at the obligation as a reciprocal obligation. So again, both parties are held to negotiate in good faith. And then you have to think about what would happen if one of the parties does not really do that. So if one of the party does not negotiate in good faith and fails to meet this obligation, what should happen with the other party's duty? Should it remain as it is, and should you require the party to continue basically acting in good faith and trying to find a solution, sticking with the negotiations, and not for also requiring the party not to go to court and not to file proceedings? Or should you then be more flexible and say, in this case, you should suspend the obligation? And the court said this question, whether to suspend or not, is not linked to whether the front undertaking is irrevocable or not. Irrevocable has a different meaning. Irrevocable means that the SEP owner cannot withdraw or take back the obligations that arise from the front undertaking. However, these obligations in the eyes of the court are not static. And then if you look at it from, I will use the words of the court here, a more practical and logical angle, then it makes no sense not to suspend the obligations of a party if the other party acts in bad faith, because factually, in this case, you cannot really have negotiations. If one party is not willing to move forward and is just trying to delay and act in this way, then of course you cannot expect that negotiations will progress and will lead to the signing of an agreement. In this case, to hold otherwise and to not allow the other party to suspend its obligations, in the eyes of the court, would strain logic and reason. The court added a further aspect here by saying that a suspension of the duties of the party which acts in good faith prevents that party from being taken advantage of by the counterparty. And the court linked this to the effects of hold up and hold out by saying that if you would allow, for example, the one party that acts in good faith to suspend its obligation, then you might allow this party to fight against hold up or hold out, respectively, depending on which side of the table the party is. Looking, for example, at the SEP owner's perspective, if you give the patent owner the possibility to suspend its duties to act in good faith and negotiate in good faith, and allow him, for example, to go to court and ask the court to find infringement and provide the needed remedies, then you would minimize the effects of holdout, because the SEP owner would not be bound and stuck in negotiations with an unwilling implementer acting in bad faith, which would nevertheless lead to nowhere. On the contrary, what the court also mentioned here, if holdout occurs, then the SEP owner should be free to pursue lawful remedies. So also from this angle, the court found that in the mechanics of the front negotiations, it makes sense to allow for the suspension of rights if the counterpart is acting in bad faith. However, the court made also a clarification here, and this is important to keep in mind, that when a party stops acting in bad faith, then the negotiation can and must resume in good faith. So the court supported this view here that if the party returns to the table of negotiations with a will to reach an agreement and acts accordingly, then you should again start negotiating and find a negotiated solution. If we look at this decision and compare this with the findings of courts in other jurisdictions, we will see many similarities, for example, with the UK case law, where the court also adopted this notion that if you have someone acting in bad faith, which could be demonstrated in proceedings, for example, if by not accepting to commit to the front determination of the court, then you would allow the other party to have remedies, and if the party changes its mind, has a change in mind, then you should have negotiations again and potentially set an injunction aside. but also you have very many similarities with the Court of Justice of the EU in Huawei ZTE, especially regarding the part where the negotiations are the obligations arising out of a front undertaking are considered to be reciprocal, that both parties have to act in good faith. So I think this is a decision which interprets the front undertaking in a way which is in line with the decisions we've seen so far in other jurisdictions as well, which is of course is good, because then you have a conformity, at least on these very fundamental questions of how to understand the front undertaking and how it basically operates.